So, good morning class. Now we start our the next PYQ session classes regarding the Indian Contract Act for specifically for UGC NET exam. And we start with the today the first class I think PYQs of Indian Contract Act, and we start with the first question, that is about the inadequacy of consideration will be taken into account by court of law. कब कोर्ट इनएडिक्वेसी ऑफ कंसिडरेशन की बात करेगी? वैसे इफ वी गो विद द वैलिडिटी ऑफ अ कॉन्ट्रैक्ट, तो इनएडिक्वेसी ऑफ कंसिडरेशन नेवर बी कंसर्न्ड. अगर इनएडिक्वेट कंसिडरेशन अप्रोप्रिएट है या नहीं है, इट्स कम्प्लीटली अबाउट द सेलर कि वो अपनी गुड्स को, अपनी सर्विसेज को कितने अमाउंट में सेल आउट करना चाहता है. इनएडिक्वेसी पे हम कंसिडरेशन कभी बात नहीं करेंगे. बट इफ देयर इज अ चांस ऑफ फ्रॉड, coercion and undue influence in a formation of contract, then it can be pleaded. अगर डायरेक्टली मैनिफेस्टली हमें ये पता चलता है कि कॉन्ट्रैक्ट किसी फ्रॉड, कॉर्जन या अनड्यू इन्फ्लुएंस के थ्रू हुआ है, देन वी कैन बी गो विद द इनएडिक्वेसी ऑफ कंसिस्टेंसी, कैन बी अ मैटर ऑफ इट. अदरवाइज directly we cannot be use inadequacy of consideration to check out the validity of a contract. Second is the communication of acceptance is complete against the proposer. Against the proposer means against the offerer. The person who make the offer and the acceptance of communication is make against of that proposer, that offerer, is when the person for whom we create the offer, it accept it and put that letter in a transit. जब वो ट्रांसमिशन में उस लेटर को भेज देता है ऑफरी, जिसे एक्सेप्टेंस देनी है, उसके बाद जो ऑफरर है वो बाउंड हो जाता है. बिफोर द सेंडिंग द ट्रांसमिशन, लेटर पोस्ट करने से पहले ऑफरर के पास टाइम है कि वो रिवोक कर सकता है. लेकिन जब ऑफरी उसको एक्सेप्ट करके पोस्ट ऑफिस में भेज देता है, पोस्ट ऑफिस में सेंड करने के लिए उसे गेट देता है, बट इट नॉट स्टिल नाउ रीच टू द ऑफर. ऑफर तक वो लेटर नहीं पहुंचा, लेकिन ऑफरी ने पोस्ट ऑफिस में उसको सबमिट कर दिया फॉर टू गो टू द ऑफरर. जैसे ही उसने पोस्ट ऑफिस में वो लेटर सबमिट करा, ऑफर बिकम बाउंड विद दैट एक्सेप्टेंस. नाउ ही कैन नॉट बी रिवोक. सो द ऑप्शन इज D is right when it is put in the course of transmission so as to out of the acceptor's power. Now acceptor can't do anything. So when acceptor put the letter in a transmission for offerer, then offerer become bound with that acceptance, or offerer now cannot be get back his words which he make in his offer. Clear? Next is special damages be awarded in a case of breach of contract. Special damages directly can be awarded in a special circumstances, not in an ordinary circumstances. When the circumstance is special and the parties are aware about it, then the special damages can be awarded. So answer is a D. Only when the special circumstances causing loss, profit resulting from the breach of contract, where both party notice of the party committing breach at the time of formation of a contract. So the party should be aware regarding that if you make the breach of contract and the another party going to be suffered with the large losses, and then the in a special circumstances special damage can be awarded by a court. Next is which of the following statement is correct? इनमें से कौन सी स्टेटमेंट करेक्ट है? प्राइस फॉर एनी कंसिडरेशन इज प्राइस फॉर एनी प्रॉमिस. इट कैन बी से इट इज राइट, समहाउ इट इज राइट. ओनली मोरल ऑब्लिगेशन, नो, इट्स नॉट राइट. ए मोटिव फॉर एनी प्रॉमिस, it also be not right. Something of value in the eye of law, it is completely right. So the 4 is completely right. If I go with the 4, let me go in another way कि second और third तो हमारा नहीं है, तो जहाँ जहाँ पे second और third है वो नहीं होगा. That is not right, that is not right, that is not right. So the that is B is also be left. So the answer is B. Acceptance is to offer what a lighted match to a train of gunpowder. That is right statement. Acceptance cannot be separated from offer. That is wrong. Acceptance cannot be separated from offer. Sorry, that is right. That is also right. Acceptance ऑफर से सेपरेट नहीं करा जा सकता, ऑफर ही एक्सेप्ट होता है. यू कैन नॉट बी से कि मैंने ऑफर आपको कुछ और दिया और आपने एक्सेप्टेंस कुछ और करी. नहीं, बोथ आर शुड बी सेम. वट एवर द आई गिव ऑफर टू यू, यू हैव टू बी एक्सेप्ट द सेम ऑफर. अगर वो आप ऑफर एक्सेप्ट नहीं करते, रिटर्न में कोई और एक्सेप्टेंस भेजते, तो वो काउंटर ऑफर होगा. ठीक है. सो द बोथ स्टेटमेंट इज राइट, but that is not a correct explanation of both of them. So the A and R is true, but R is not a correct explanation of I. Next is the defense of non est factum is available contracting party who is committing the mistake as to the it. We done that thing in a mistake. Non est factum mean I am not the person who is agree on that thing. Whenever the contract is formed, you have to be the similar consent with the both of parties. दोनों पार्टीज की सेम कंसेंट होनी चाहिए. इफ आई साइन द कॉन्ट्रैक्ट बट आई एम नॉट बी have the consent in the same manner as the another party, I think something different, and the party who make that contract they think something different, so the consent regarding the nature of contract is not similar, then we take the defense of non est factum, and that is the answer is B. अगर मेरी और आपकी कंसेंट नेचर ऑफ कॉन्ट्रैक्ट को लेके सिमिलर नहीं है और बाद में मैं ये प्रूव कर दूं कि नेचर ऑफ द कॉन्ट्रैक्ट आई थिंक डिफरेंट एंड यू थिंक डिफरेंट, सो दैट कैन बी अ पार्ट ऑफ मिस्टेक, एंड दैट मिस्टेक बिकम द नॉन एस्ट फैक्टम डिफेंस रिगार्डिंग द breach of contract. Clear? Then we come with the consideration is the recompense given by the party contracting to the other. Above definition is attributed by the Blackstone. Which of the following statement is correct? Acceptance may be made in the prescribed manner indicated by the offerer. It can be right. Offerer जो उसे कहेगा, but may word is not be right. ऑफर जैसा कहेगा उसी के हिसाब से एक्सेप्टेंस होनी चाहिए, तो एक्सेप्टेंस हैज टू बी मेड इन द मैनर प्रेस्क्राइब्ड एंड इंडिकेटेड बाय द ऑफरर, एंड आंसर इज अ सी. इन विच ऑफ द फॉलोइंग वी अप्लाइड द फ्रस्ट्रेशन ऑफ कॉन्ट्रैक्ट? Taylor versus Caldwell is a landmark, and the first case will define the frustration of contract. Apart from these, Krill and Henry and Paradine versus Jane is also be the same. So answer is 1, 2, 3 are the cases which are deal with the frustration of contract. Next is an agreement made with consideration is void. Agreement made with consideration is void unless it is writing and registered. Okay, agreement made with consideration is void. No, agreement made with consideration is valid, so the assertion is wrong. Because of section 25 subclause 1 of the contract act stipulated, so no, contract act of 25 subclause 1 is about without consideration contract is void, so the both A and B are wrong here. Answer is a B. Next is compensation is recoverable for any loss or damages which the party knew at the time of contract as unlikely to result from the breach of contract. Line is quite right if that unlikely is become the likely, because the unlikely is it, so the assertion is wrong. Because of the above rule is laid down the Handley versus Baxterdale case, that is also be wrong, so the both A and R is wrong, and the answer is B. And the next question is about the doctrine of frustration of contract was laid down in a Taylor versus Caldwell cases. That case is quite important, so kindly noted that case, that question should not be wrong with you. Which of the following statement is correct? A person who wrongfully rescinded a contract, wrongfully rescinded तो पहले ही गलत हो गई. A person who rightfully rescinded the contract is not entitled, that is also wrong. A person who has rightfully rescinded a contract is entitled by compensation for any damages which he has sustained through non-fulfillment of contract. C is right. जो contract को rescind कर रहा है वो जो भी damages होंगे उसे वो recover कर सकता है. Every person इज कम्पिटेंट टू कॉन्ट्रैक्ट, तो कॉन्ट्रैक्ट के लिए भाई सबसे पहले तो मेजर हो, ठीक है, मेजोरिटी मिल गई. फिर साउंड माइंड हो, साउंड माइंड मिल गया. नॉट डिस्क्वालिफाइड बाय लॉ हो, नॉट डिस्क्वालिफाइड बाय लॉ हो गया. सो आंसर इज अ डी. इफ यू गो विद द अबव वन, माइनॉरिटी ये वाला रॉन्ग हो गया. मेजर विच इज नॉट सब्जेक्ट, हु इज साउंड माइंड इज नॉट डिस्क्वालिफाइड एंड इज नॉट डिस्क्वालिफाइड बाय लॉ, any law which he is subject. Who is the age of majority according to law which he is not subject, that is wrong. Who is the age of majority according to law which is subject, who is of sound mind and is not disqualified from contracted by law to which is, that is also be somehow wrong. So the answer is D. Which of the following statement are correct? Adequacy of consideration is necessary, that is wrong. Adequacy of consideration is not that much required. Adequacy of consideration, which of the following statement are correct? Adequacy of consideration is for the court to consider when the contract is sought to be enforced. ये भी कोई जरूरी नहीं है. The court will require whether the consideration was equivalent to the promise which he has given to return. The court is required whether the consideration is equivalent to the promise which was given in return. That is wrong. Inadequacy of consideration may be taken into account by the court in determining the question whether the consent of promisor freely given. Inadequacy of consideration can be taken in consideration if the question raised against with the consent. If the consent is under an undue influence and the coercion, then we taken it consideration. So the answer is 4 only is correct, and all are 3 are the wrong. नेक्स्ट इज विच ऑफ द फॉलोइंग स्टेटमेंट इज आर रॉन्ग. कौन कौन से स्टेटमेंट इसमें रॉन्ग है. क्लेम आर डैमेज इज डेप्थ. नो, दैट इज रॉन्ग. तो एक तो फर्स्ट स्टेटमेंट रॉन्ग है. डैमेज आर कंपनसेटरी नॉट पेनल. दैट इज राइट. When the plaintiff suffer no loss, the court may still award the nominal damages. That is also be right. In ordinary cases, damages for mental pain suffered caused by breach of contract are not allowed. That is also be right. So the only one is wrong. Answer is C. It is well settled that if when wait, I just make broad this. It is well settled that if when there is a frustration, the dissolution of contract does not occur automatically. It depends upon the ground of repudiation or breach or on the choice of election of either party. It does not depend upon the effect what was actually happened on the possibility of performing the contract. That is right, and that principle are held in the Dixons Limited versus James B. Fraser. Both A and R is right, and A is the correct explanation of R. Compensation is recoverable of any loss or damage arising unnaturally in the unusual course of thing from breach of contract, or which party did not know at that time the contract is likely result of from breach. That is wrong. There is no need of an unusual course of thing and breach of contract, and that principle are not stipulated in the 73. So both A and R are wrong. Doctrine of frustration of contract first taken in a Taylor versus Cardwell. We recently done. I tell you that is an important question. Which of the following statement is correct? A contract is voidable because it caused by mistake of any law of force in India. That is wrong. That is wrong. A contract is void. No, it does not make any effect because of the mistake of law in an Indian law does not make any effect. Contract is valid, not voidable. A mistake as to law not in force in India has the same effect as a mistake of fact. That is right. The contract is voidable merely because only we need to be the right one. So the answer is a B. Let me read the another options also. The contract is voidable merely because it was caused one of the parties to it under the mistake as to be matter of fact. Nay, if the one party is only under the mistake, so the contract is valid, not voidable. Where both party to an agreement under the mistake as to matter of the fact, both party under an agreement under the mistake no matter essential of the agreement is not void, then it is a void. So these are wrong, these are wrong, these are wrong. Answer is a B. That is right. Last question for today's class is about an agreement without consideration is valid. That question is quite be difficult in respect of reading. What you need to do, you need to be make another way what cannot be an answer in this case. अगर क्वेश्चन पूछता है an agreement without consideration is valid, बिना कंसिडरेशन के कौन सा एग्रीमेंट वैलिड होगा. सो in this option I go with the B. B is a promise to compensate for something done. ये वाला valid होगा. is promised to pay a debt barred by limitation law. ये वाला valid होगा. तो दो आंसर तो इसमें ठीक है. It is writing and registered. That is also can be valid in a case of love and affection and the registration case in a registration act. It is made by two minors. दैट इज डिफरेंट. तो ये वाला तो वॉलिड नहीं होगा. तो तीन सेम है, ये डिफरेंट ऑप्शन है. तो आंसर इज सी. नाउ वी अगेन गो विद द क्वेश्चन. एन एग्रीमेंट विदाउट कंसिडरेशन इज वैलिड. एग्रीमेंट बिना कंसिडरेशन के वैलिड नहीं होता. कंसिडरेशन इज एसेंशियल थिंग. सो द लाइन फर्स्ट इज इलॉजिकल समहाउ, बट इफ यू एडेड दैट लाइन with these exceptions then it is valid unless it is made by the two minors. अगर दो माइनर्स के साथ है तो वो void होगा ही होगा. सो अगर मैं ऑप्शंस में देखूं तो तीन ऑप्शन सेम है, सी एक अलग है. सो वी गो विद द सी. वेन एवर यू फाइंड दैट काइंड ऑफ क्वेश्चन यू आर नॉट एबल टू अंडरस्टैंड, तो आपको करना क्या है कि जो ऑप्शन अलग है बाकी 3 ऑप्शन से, वो उसका आंसर होगा जो अलग बात कह रहा है। 3 तो आंसर हो नहीं सकते, आंसर एक होगा, तो जो अलग है वो आंसर होगा। अब ये क्वेश्चन ये कह रहा है कि वह एग्रीमेंट बिना कंसिडरेशन के वैलिड होगा जब तक कि वो माइनर के द्वारा ना बनाया गया हो। अगर वो माइनर्स के द्वारा बनाया जा रहा है तब वो वैलिड नहीं होगा। द वर्ड इज अनलेस, जब तक कि वह माइनर के द्वारा एग्रीमेंट नहीं बनाया गया हो, बिना कंसिडरेशन के भी वैलिड हो जाएगा इन 3 केसेस में। अब लेकिन अगर वो माइनर के द्वारा बनाया गया तो वो वॉइड होगा। क्लियर? So that is the class regarding the PYQs of Indian Contract Act. Kindly go and read with it and take the all classes of a lecture series regarding the Indian Contract Act. And if you find any difficulty, then you can go with my Telegram group and ask the any question in respect of that. Thank you then. Bye.